Hello, I'm Dominic Walker, JMW's Inside Man, and with Claire Brierley. Claire is an associate solicitor in JMW's Wills and Trust Department, and she specialises in disputes of wills and trusts. Hello, Claire.
Hi, Dominic. You okay?
Very well, thank you. So, Claire, I've read your blog online about the Duke of Edinburgh's will. Just wonder if you could give me an idea of what's happened, please.
Yeah, of course. So basically, a decision's been made in relation to Prince Philip's will. Usually what would happen is when somebody dies, the person responsible for the estate will apply for a grant of probate. And that process just allows you to deal with the estate and distribute assets as according to the will. Now, the provision is slightly different with royal wills in that when the grant of probate is provided, in normal cases, the will is also published at the same time. So anybody in the public can look online and apply for somebody's will, anybody's will. You don't have to have a particular interest. With royal wills, the system's slightly different. And historically, there's been a process where a royal will hasn't been made publicly available after the grant of probate, as would be the case normally. So the decision here has been made that whereas usually it's not made public, there's a provision whereby after 90 years from the grant of probate of Prince Philip's will, potentially it will be made publicly available.
And the Duke of Edinburgh was always outspoken. Why would he keep his will private?
He was, yeah. I think generally it's been historically set down that royal wills are maintained and private, and the basis of that is that there's no public interest, although obviously there'll be a lot of curiosity, and given his outspokenness, probably a lot of people would like to see what's in there, but I would imagine he's prepared his will on the basis that it's not going to become a public document, and the idea is that it protects the interest of the Queen and the royal family and the close members of that family, in the basis that there's no real genuine public interest for people to know what's in there other than just curiosity.
And what will happen in the future, Claire? Will future royal wills be kept private as well?
Well, so the provision in this one is that in 90 years from the grant of probate, a select group of people can have a look at the will. Basically, they can unseal it and see if at that time there is any public interest in it being provided publicly. So there is a potential for it being made public, but there's no guarantee it will be. And obviously in 90 years time, in terms of anybody now that wants to look at it, you know, the time's clicking on, you might have a limited, you might not be around to look at it basically. So it does kind of open the door, but it's relatively restricted in that there's a slight provision, but there's no guarantee it will actually go forward on that basis. And it could be that it's resealed indefinitely or for another prolonged period at that time.
I find it very fascinating, Claire, and I know that my will would never ever be kept private. But thank you very much for your insights. Really interesting to hear that. And if you'd like to contact Claire with regards to any will disputes, you can email it insideman@jmw.co.uk or call 0161 82 81 999. I'm Dominic Walker, JMW's Inside Man.